repeat.
All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here, coming at you live. Not quite to the studio yet. I was hunting down in Maryland and managed to catch a deer. Didn't release it, so here I am, almost to the studio, but we'll be able to take your calls anyhow, 540-0580. So feel free to call in with your legal questions. Whatever you want to know, 540-0580. We'll put you here live on the air, and we'll talk about whatever you want to talk about. If you have a traffic ticket, custody matter, maybe a personal injury, wrongful death case, problems with an estate or the neighbor's fence, you know it, we'll answer it, 540-0580. Today, though, I want to start by talking about the governor's new lawsuit. Somehow, the governor of Pennsylvania was delegated, and apparently there was a Commonwealth Attorney's out. I'm going to back up for a second. So the Commonwealth Attorney General, who's on her way out, or is out now, delegated the power to bring a lawsuit against the NCAA to Governor Corbett, and he did. And he brought it on an antitrust ground. And if you heard me on Durgan the other day, you can probably guess what my feeling is already, but I'll reiterate it here. It's a frivolous lawsuit. Penn State was a party to the action, and they agreed to the sanction. They had the right to have a hearing, and they chose to waive that hearing and take the sanction because the NCAA was threatening worse sanctions, including a, quote, death penalty for the football team. Now, it reminds me of clients in criminal matters who, when offered a plea bargain, take the plea bargain, then later claim that they didn't really want to take the plea because there was a threat of, more time in jail or things could have gone badly. And the answer courts usually give is, well, if you didn't want the plea bargain, you should have taken the trial, and then you'd have to live with the consequence, whichever side of the equation you land on. So sometimes when you take a trial, you get the death penalty, and sometimes you get acquitted. But if you take the plea, to life in prison or 20 years or something, you can't just come back later and say, I'm not happy, or the sanctions were too stiff, or we didn't appreciate the nature and quality of how harsh the punishment would be. So it's very unlikely that a federal court is going to allow the governor to unwind an agreement. The other major issue, though, is that the governor is not really a party to the action. Penn State University is. And they signed an agreement with the NCAA, capitulated to the sanction, and entered into this binding agreement. And while it may have harmed Pennsylvanians and it harmed the football program and it harmed a lot of people who had nothing to do with the scandal whatsoever, I don't disagree with that at all. In fact, I was a big believer as a Penn State alumni that Penn State University should not have rolled over and agreed to that sanction in the first instance. But that's the problem with rushes to judgment. That's the problem with knee-jerk reactions. That's why we lawyers like to try to slow things down so that one can really think through the legal consequences. So I'll be interested to hear what you guys have to say, 540-0580, about the governor's lawsuit. Is it a taxpayer money? Is it a good idea? Is it just a political ploy? He's gotten some really bad press in the USA Today, the New York Times, and some other major online sports publications. I know that one of the criticisms is the governor said he was waiting till football season was over, but other people have said the whole point of this debacle was that football got too much leeway and that it wasn't treated as a sport. It's sort of, dog's tail wagging the dog. Football was running the university. So if we think about it that way, maybe the criticism level against the governor and some of these things is true, that he shouldn't have waited till football was over because it didn't make a difference. But it shouldn't be about football. It should be about the merits of the case. But I don't think it's a meritorious case. I don't know what you guys think about that. So I'm hoping we can discuss that a little bit today, 540-0580. And, of course, as you know, if you have other questions about any area of the law, we'll talk about those as well. There's also a major local legal story I wanted to mention before we start taking callers, which involves DUI law. Judge Clark from the Dauphin County Court of Common Pleas issued a opinion the other day where he basically found that the breathalyzers employed by the Commonwealth are not capable of taking an accurate breath sample such that one could be presumed to be accurate above a certain range and below a certain range. And the range is from 0.05 to 0.15. So some of you who know the DUI law know that 0.16 is the magic number for the highest tier. Well, 0.16 DUI for a lot of people is the difference between, say, a year in jail or 90 days in jail, or the difference between 30 days in jail and 90 days in jail, the difference between 5 years of probation or 2 years of probation or 6 months of probation. That little number can make the difference. And basically he's saying that the breathalyzer is not accurate. What happened, Justin McShane, an attorney from the local area, brought the case, and he brought in some nationally renowned chemists who pointed out that the way the machines are calibrated by law, and the judge cleverly and wisely points this out in his opinion, that nobody's doing anything wrong. The statutes and the regulations that were promulgated years ago when the DUI law didn't make a distinction between 0.15 and 0.16 and 0.17, etc., were written. The calibration numbers are from 0.5, a 1.0, and a 0.15. And as a result, curve is only good between those data points, and that's what they call a fall off from the curve. But because no one can tell you the exact point of the fall off, the numbers above and below the sample tests are considered scientifically valid by chemists. Now, why courts have just figured this out is basically because some clever lawyer finally brought a chemist in, finally sat down with the court, and the court gave a lengthy hearing. And actually, the opinion makes quite a big deal about the fact that the judge invited the Department of Health, the State Attorney General's office, Office of General Counsel, and PennDOT to participate. And apparently PennDOT did participate a bit initially, but his point being that he believed that this was going to have a statewide effect, and I agree. The science is absolutely correct. The legal conclusion is absolutely correct. The opinion's a little harsh on the Commonwealth if you read it. We'll try to post it for you. I haven't quite figured out how to put a PDF up on my Facebook page yet, but we'll do that, and you can take a look at it. The long and short of it, though, if you have a DUI, or you know somebody who's gotten a DUI recently and their breathalyzer was used, they may be able to escape the consequences of the highest tier. It doesn't mean they're going to walk or be found not guilty necessarily, but it does mean that you have a lot of leeway. And trust me on this, courts and prosecutors, particularly in the other counties where this decision is not precedential, because a Dauphin County decision is only binding on Dauphin County courts, they're not just going to hand you this favor. So if you know somebody who's out there who's about to plead guilty, or even has pled guilty but hasn't been sentenced yet, or maybe who's been sentenced recently but is not wanting to remain sentenced, you should strongly encourage you to call a lawyer and investigate this, because I believe sincerely that a lot of people will be able to avoid the harsher consequences. And for some people, this means something as important as keeping your gun rights. A second offense DUI below 1.6, you can keep your gun rights. Above a 1.6 and above, you cannot. So not that we're encouraging you to get a DUI or that anybody should reap the benefit, but also if you're going to be prosecuted, you should be prosecuted with scientifically accurate evidence. And if the government's going to change your probation from 2 years to 5 months, or your jail time from 90 days to 1 year, then they need to use scientifically accurate evidence. And that was the point of this decision. And it doesn't preclude some fixing, but the legislature and or the bodies that regulate the testing of these machines, which would be the Department of Health, will need to come to court and rejigger I shouldn't say come to court, but come to the legislative bodies either need to pass the laws or the administrative bodies need to promulgate new rules and change this around. And if they do that, it will solve the problem absolutely. So 540-0580, when we get back from the break, I will answer your legal questions here on the air.
Welcome back. Carl Rominger here, 540-0580. Now I'm in the studio. I'm actually live on my microphone now. Bob, you're on the air.
Yes, Carl, I like your show.
Thank you.
Listen to it when I can. I had a quick question. A couple of years ago, I was involved in an estate with a elder relative that was a hunter. We sold all the rifles and shotguns to a gun store, but I got left with bags of ammunition, 30-06, 30-30.
Yeah.
And a 12-gauge, 20-gauge shotgun shells. And I was wondering, I saw an ad on Craigslist for some guy that wanted to buy. He said, I buy ammunition. And I was wondering, it might be paranoid, but is it legal for me to sell it?
It
I
is.
don't have a license or anything.
No, but individuals can transfer it back and forth. Walmart doesn't have to have you have to have a license to sell the guns.
I see.
And commercially sell guns. You can still sell guns between private individuals. So, no, you could sell that ammunition.
All right.
Now, the only other thing I would do, though, is look for the person's credentials or something, because I do think you could get in trouble if you say, for instance, sold ammo to somebody who is a known felon, for instance, or known drug user, or the like.
Oh, that's a good idea. Yeah. Like I say, I don't know him. I'll think about that, see if there's a way to do that before I do it. But at any rate.
That, or the other way is, I mean, if you don't want to sell it but just want to get rid of it in a safe way, would be to take it to a local fish and game club and offer it up.
Yeah, I did. I tried that once. There's one about 5 miles from me, and I posted a notice, and months went by and nobody responded. So.
Yeah.
But at any rate, that's a good idea, though. Okay.
All right, good luck.
Thanks a lot.
No problem. 540-0580. The other Bob is on the air. Bob, how are you?
I'm good. How are you?
Good. What's going on?
Hey, I hope you didn't have too much problems with your deer.
It wasn't very large, so it was okay. Actually, that was the funny thing. My buddy, there's 4 of us hunting, and the 2 of us needed to be back because he needs to get a kid to Baltimore. And we said, we got one last drive here. It'll take 15 minutes. The only thing that could go wrong is we could get deer.
Sorry to hear that. My situation is I'm working on an estate. I have 8 accounts that were with financial institutions and set up with either beneficiary, transfer on death, or in trust for. And so these are non-probate assets.
Right.
And I'm wondering if I get to a point where I have to file a last and final account with the court if a family agreement is not reached. Are these assets included on that accounting?
They don't have to be included in the family accounting. They could be, and you could just note what they're for or who they went to. But you have to list them in the estate tax return.
That's not necessarily. If you file with the Pennsylvania Department of Revenue, the notice of transfer, if you check the bill beneficiary separately, they are not listed on the...
Right, but then you still has to be a separate return then filed on that, or a payment made based on the third party who's going to pay it.
Right, you would just pay directly to the register of will.
And the only other little rub on that I'm aware of is you have to be careful if you have a will, because some wills do direct that the taxes be paid by the estate on those things. But if it's silent, then either can do it, but it'd have to be part of the family agreement, or generally speaking, most people would push them off to the person who gets the asset, obviously.
Yeah, because what I'm running into is one, they had some mutual funds, and one of the organizations specifically asked for the request for waiver or notice of transfer, and then when I provided it with the 2 individuals listed on there as getting 50%, they need to contact the individuals to say, is it okay if we submit this form?
Right.
Well, if I got one of the individuals say no, then what recourse do I have?
Right.
So can I then transfer the funds for that individual into an estate account? I
don't think you transfer the funds, but the tax has to come from somewhere, right?
Yeah, and the estate doesn't have enough to pay the tax in this case.
Gotcha. So yeah, that the money would have to come out of their share, and if if it gets distributed directly to them, it's gonna be tough to cut it out. If you
Right.
if the payment were to get made directly to them, there's no guarantee the estate's going to get the tax money back or that they're going to pay it.
That's correct. That's my concern.
Yeah. So I would take the position. Now, is that person getting anything else out of the estate? Because you can also account for it that way, too. I mean, if there was enough liquid otherwise.
No, there's not enough to account for it. That's the problem.
Right.
And I was planning on doing direct distribution to the individuals, but if one person says, no, I don't want to be billed separately, then I would have to put it on the estate tax return, but I don't have enough money to pay it out of the estate.
Right.
So I'm caught in a rock and a hard place. So I'm looking for some advice on how to handle it.
Well, are these people willing to? I mean, what's the answer with them? Have you already got the I won't cooperate?
One wants to cooperate and one is hesitant.
Well, I would sit down with them and explain to them why you're doing this. But maybe if they want advice of counsel, they should encourage them to go talk with a lawyer about how this is being done for the ease of the administration. But they're going to be responsible for the tax unless the estate pays it, and the estate's not going to pay it unless it collects the funds.
Correct. So how do I collect the funds if they don't want to pay it themselves?
Right. Well, that's the problem. That's the conundrum. And I don't know the answer to that, except what you're saying is, can I capture that money or that value somehow?
Correct. That's what I'm asking.
And the mutual fund, what is the mutual fund willing to pay it into the estate, or are they saying because these are beneficiaries of the mutual fund, we're going to pay it out that way?
Well, I haven't asked the mutual fund how they're going to handle it yet.
Because that might be important to know. If they tell you we won't pay it to the estate under any circumstance, we're going to pay it directly to the beneficiaries named, then I guess that's the problem.
Right.
If they say, we'll pay it to the estate, then you can collect it to the estate and pay it out and collect a tax on it and solve it that way.
Got it. Okay. That's pretty much what I needed to hear.
Yeah.
All right.
All right, my friend.
That answers my question.
Yeah, and it's interesting, isn't it? Because it is complicated by how do you want to handle it, and then it's complicated by will the people cooperate. And that's where sometimes maybe, like I say, I assume you're handling all the estate. Is there a lawyer working with you or doing it on your own?
I'm doing it on my own.
Yeah, which is fine. You're running into that, one of your relatives or beneficiaries is like, well, I'm not sure you're doing it the right way. Or I'm not sure I want to do it that way. And the answer is like, why? And so if you do, it might just need a lawyer or somebody to explain it to them at some point. Or you can just have them listen to this podcast.
Yeah, understand.
All right, my friend.
Okay, hey, thanks for your time.
No problem. Take care. 540-0580. I want to let you guys know I gave up Lent for my New Year's resolution. So that was my New Year's resolution for 2013. John, you got a comment on the ammo.
Carl, yes, I do. Good afternoon to you.
What's going on?
Well, I just wanted to give you a call and let you know that I'm sure I'm not the only one that feels this way, but that I think that your response to the gentleman with the ammo that he wants to get rid of was pretty savvy. And so I wanted to tell you that.
Well, thank you.
I wanted to also tell you that it's considering all of the things that are going on in society today, you couldn't have picked a better thing to tell him.
Yeah, because here you had some guy. So I had some guy on Craigslist. He wants to buy guns. I wonder why. Or in this case, ammo. But I wonder why he's doing it there instead of But I understand that there are people who buy used ammunition for two purposes. One is to recycle it, and one is to shoot it.
Okay. Okay.
If you've got a lot of old ammo and you buy it off somebody, you can do the math on this. The lead has value, right? The copper has value, and then the brass has value. So depending on what you get and what you pay for it, you just have to decommission the rounds. Not sure something that's what I want to do in mass in my garage. but people do that.
Right.
But on the other hand, if a guy likes to shoot 9mm, and they go through 1,000 rounds in a Saturday, if they can find a way to get them cheaper, hey, why not?
Absolutely. I also wanted to pro-offer my contact information, of course not over the air, but to the station, in the hopes that maybe you might be able to speak to the gentleman through the radio and let him know that he can contact me and I can solve his problem.
Gotcha.
I can tell you that, of course, you don't know me from Adam, but I can tell you that it's he would be. Let me put it this way: he would be willing to transfer the ammo to me in a manner in which would be safe for him and all on the up and up.
Gotcha. Well, hold on. We'll put you on hold, and during the break, we'll grab your information.
Okay. Thanks a lot. Thanks
All
so
right.
much, Carl.
All right, man. 540-0580. Who's next? Ann, you've been waiting patiently. What's going on? Ann, you're on the air.
Oh, Ann? Oh, I didn't hear you say Ann. Yes. I had a question with regards to a pretty bad fall that I took in a business establishment about 3 weeks ago.
Yeah, what happened?
It was clearly their fault. There was a cord that was extending out into the owl that had looped. It was attached to a vacuum cleaner, and my foot went through the loop, and it threw me forward. I was walking pretty fast, so I went down pretty hard. It pulled my shoe off because it caught right through the loop.
How long ago did that happen?
About 3 weeks ago.
Okay. And what kind of injury do you have?
Only my injuries were not severe to the point where my injuries were badly bruised knees, very badly, swollen, and complete stowed my body because I landed flat out front first. I'm 73 years old, so it doesn't take much of that type of fall. They do have it on surveillance camera.
Okay.
And they know it is their fault. It was no fault of mine. I did not pursue anything because they were minor injuries.
Mm-hmm.
And I did not contact a lawyer. So I guess and the fact is they didn't have the courtesy to follow up. They took a complete report, but I never heard. They never.
Well, the only reason they take a report is to document it for future liability purposes,
right,
and for their insurance company. They don't really care about you. Let's just be honest.
Well, I have been a customer there for 6 years since they opened. It's a large business establishment with locations throughout the United States. But my only question is, and I've had opportunities in the past with incidents that I could have sued. I'm not a suing type person, and I don't want to sue. I was just twigged because I thought they should have. The embarrassment of the fall. I'm still having residual effects.
Right. Well, the answer is that you don't want to sue. You don't want to sue. I always like to tell people, there's a reason. Reason why we have lawsuits, and if you were actually hurt, the other effect of suing is it sometimes sends the message to the offender to be more careful. And while some people will poo-poo that, if you ever go up to Canada or other places where they don't have as developed tort laws we have here, you can go to a playground and find a lot more rusty and sharp things. You can find a lot more unsafe conditions because it's kind of like private regulation. It's death by 1,000 cuts to big retailers if they don't take care of business and make sure that their environment's safe, because they'll attract a bunch of lawsuits. And so while some people will say, well, these people shouldn't sue if they don't have terrible injuries, the flip side is suing is a good way to remind the business to not let the cord hang out again.
Well, I guess other than saying suit, I was going to call and inquire, only because I just felt a small entitlement, only because it was holiday. I was down for 2 weeks, literally. And this week I'm not moving around. And I guess if they would have been nice
Yeah, well,
call or say, you know.
Come see me and we'll sue them. That's what lawyers do. Otherwise, call them and ask for an apology. But just remember, corporations don't have emotions. I got to go to break, okay?
Okay.
All right.
Thanks.
Bye. 540-0580. Welcome back. Carl Rominger here. We heard in the news there, people are saying they're not going to hold gun shows in proximity to the school shooting. And, just want to do a little thought experiment with that. So what's the appropriate distance? Is it 20 miles, 50 miles, 100 miles, 500 miles? And what's the appropriate time frame? 1 week, 10 weeks, 3 years. So it's kind of a slippery slope if you start to say that every time that there's a shooting, it's not appropriate to buy or sell a gun or to retail a gun or have a gun show. And I'm not trying to depreciate the magnitude of the event, but just saying that if we follow that logic, then and we say, well, we just won't have a gun show within 2 weeks of a shooting within such and such distance, you discover that a lot of gun shows would have to be canceled near, major urban areas and other large gun-free zones where there are shootings every day. And I feel like that's the problem here is they're sort of saying, well, you can't sell guns in this environment. That's buying into the argument that the cause of that tragedy was the availability of guns. And not the fact that there was a complete nutbag who was allowed to walk around in society and who should have been in a straitjacket somewhere. 540-0580. Jane, you're on the air.
Did you say Jane?
Yes.
Oh, I'm sorry. I'm calling about a revocable trust. Is there any way to find out who the beneficiaries are on revocable trusts after the person has died?
Well, whoever has the revocable trust document would then know that.
Well, I was recently checking on unclaimed property and thought just for the heck of it, I'd put this fellow's name in. This is another state. Mm-hmm. And his revocable trust came up in unclaimed property. Now, at the time he died, he had told me, before he died, he had told me that he was putting my name on. But being me, I said, I don't want to hear about that. I don't want to talk about that. And he died about 2 months later and didn't get around to it. But the one person whose name was on the trust was an ex-wife who died before he did. Mm-hmm. So, his bank was the administrator of his will and everything, and they set up the trust. And when I talked to them, they authorized me to handle the funeral and bring him back to Pennsylvania and all of that. Mm-hmm. But I asked if my name was on anything, and they told me it was not. So I was not able to find out then who the beneficiaries were, and right. I just let it go. But then now checking, I find out these trusts are with the state. And
they haven't been claimed.
They have not been claimed.
Right.
So I thought the bank would just follow through and find the beneficiaries.
Well, if the ex-wife was the beneficiary, it's possible that her estate and then its progeny have become the beneficiaries. It all depends on how the trust is written, too.
Yeah, but apparently they don't know about it. And I don't know who the person was, and that's why I'm asking, right. Is there any way to find out who the beneficiary is?
The only way to do that would be to get a copy of the trust and look at who's named in it. But presumably the bank, as the executor, had a duty to try to find those people.
And they did not.
And if they didn't find them, then they just had to exercise due diligence. So that would be the only question, would be to go back and find out what due diligence they did to find them.
Okay.
If they did no due diligence, I guess you could go to a court and say, hey, the executor screwed up and didn't do due diligence, and ask the judge to empower you to help find the people.
Okay. And how would I find a copy of the trust?
Well, that's somebody. My will could say that there's a revocable or irrevocable trust document somewhere, but if nobody finds it, it doesn't exist, right?
Right. But it's with the state. I found it. The state would have it?
They may have a copy of it.
And
or the courthouse file for the estate may have it as well.
Okay, I did get a copy of his will, but it's not listed. It's not mentioned in the will.
Yeah. So don't know. There's no great way to. There's no there's no registry of that stuff. So.
Right. So
okay.
I would have to contact the state and
see if they actually have a physical copy of it. Yeah.
Okay. Okay.
Okay.
Okay. Thank you very much.
All right. Good luck.
Bye.
540-0580. Did we get Dave's information off line one? Gotcha. Is he still holding, or is that different Dave? Oh, too many Daves. Dave.
Hey, Carl, how you doing?
Good. What's going on?
Hey, I was listening, and I had another idea for that fellow that had the ammo.
Mm-hmm.
And see, I'm a ammunition collector, and believe it or not, people collect old boxes of ammunition, shotgun shells, 22s boxes and such. And depending upon how old this stuff is, I couldn't tell from what he was saying that, what kind of age we're talking about here. But his best bet really is to take it to a gun show, and you'll see lots of tables of guys there that, deal in those kind of things. And he might have some rare and valuable boxes of ammunition there. Of course, everything in that market is predicated on the box is in great shape and it's all full and it's to the right ammo and no one drew on the box. You see a lot of old boxes of, old hunting ammunition that people drew all over or wrote prices on. And that, degrades the value considerably.
Like baseball cards.
Exactly. And, some of that stuff is very pricey. For example, from my father's estate, I got an old yellow box of the old Western 3030s, the silver tip. It was an all yellow box. And that stuff's selling for like $50 a box. So he might have some valuable stuff there. Granted, it's in the right shape and it's all original and everything. And I'm sure if he goes into any show, he'll be able to at least sell it to a shooter if no collectors are interested.
Got it.
And usually that's your best place to bring the top buck.
Interesting. Thank you very much.
You're welcome, Carl.
Take care, Dave.
Bye-bye.
540-0580. John, you're on the air.
Yeah, you were talking about the Corbett suit.
Yes.
And you're saying that Penn State had its shot and didn't ask for a trial. And it seems a little ironic that you're making that case when your team is looking for another bite at the apple, so to speak.
No, we didn't enter into what's called a settlement. And that's the difference, and that's where a lot of people, and I'm not trying to say you're confused, but where people get confused is there's a difference between, in other words, had Penn State simply said to the NCAA, we want a hearing, and they lost the hearing, they could appeal the hearing. So that's part of the process.
I understand that they didn't, but here's another point. Corbett is representing a different constituency than Penn State. He's representing the citizens of the Commonwealth, and they have an interest in making sure that their tax dollars aren't squandered on paying fines.
It's strange because he was also on the board of trustees at the time.
Okay, he's wearing a different hat now.
Right. He's not representing the people, though. He's trying to claim he's representing the people. However, the harm is not to all Pennsylvanians.
But it's harm to me because that's the big university. It gets a lot of tax dollars. A ton of people have gone there, and
yeah, I hear what you're saying, but I just want to make sure you understand the federal courts, the type of standing he's claimed, which is basically, hey, I'm your dad. That's the translation of it. Okay, I'm everybody's father, and I want to take care of my kids. The federal courts have said that form of standing generally doesn't apply in cases like this.
He doesn't have standing. Is that your?
I'm just telling you what the research says.
Okay.
And that's his problem. And here's the thing: look at the timing of it. And when did he do it? He did it at the last possible instant when Kane's about to take over and she's about to investigate him for the delays in the case.
Maybe it was politically motivated, but I think a lot of people feel pretty strongly about those sanctions. And I think at some point maybe this is just a pretext for getting together with the NCAA and finding some basis for walking them back.
To walk it back.
Way too strong.
And listen, I think I said that earlier though, is that's my thought on the matter is the other thing Penn State's done, okay, is they have all these potential civil lawsuits against them. And they've sort of said, well, we're going to settle with everybody. They're not asserting any of their legal rights. A lot of those cases would be time barred in civil court. A lot of those cases, Penn State, under any normal theory of legal liability, has no legal liability in a lot of them. And I understand they're doing it for public relations purposes, but that's part of the problem is they sort of agreed to the NCAA sanction for public relations purposes. And, if you make a bad choice, you're right, rolling it back. So maybe Corbett can try to come in on the outside and say, all right, you guys screwed the pooch, so I'm going to try to help you roll this back now. I mean, that's probably the best light I would put it in.
Okay. Well, listen, if you guys, do a good job, maybe
Well, I always thought about it. What happens if the chief defendant wins his appeal and gets a new trial? Does that stop the $60 million sanction in the meantime?
Well, I hope it does. Yes.
Yeah. All right. Thank you very much.
Take care.
Bye. Got to go to break. Oh, boy. It's an international world. I see Justin Bieber's being criticized by members of the Filipino government for making a mockery of their prize fighter over there got knocked down or something, and he put up a Twitter pic of the Lion King standing on him and something else. And so they're saying they want to ban him from the Philippines. It's going to be very difficult when you think about it. That's why I think about the beauty of free speech here in the United States. I can Twitter pick anything I want, or if you go to my Facebook page right now, you can see some not so flattering photos of me and my deer, or me in the studio here in my hunting clothes. But people can put up whatever they want, and for the most part, the First Amendment's going to allow it in this country, so you're not going to get that kind of blowback. But all around the world, governments have the right to and the power to, under their laws, punish people for all kinds of things that we would think were perfectly normal, or at least not a big deal here. So it's very interesting. 540-0580. Gary, you're back. You're on the air.
Yeah, Carl, I was just listening to the last caller about the Penn State deal. You and Amendola were the attorneys of record for that case?
For one of the defendants, yes.
Okay. Should sometime down the road, if he wanted a retrial based on incompetent attorney.
Right, we call that a Post-Conviction Relief Act based on ineffective assistance of counsel.
Okay, now would the second set of attorneys be able to call you and Amendola
as witnesses? Yes,
witnesses,
and
to defend yourself, or to
and actually, let me tell you, this is I get involved in these. I want to say quite frequently, because here's what happens: if you represent somebody in a murder trial or a large sex case or anything where they end up with a long time in jail, okay. And so let's just say I have a guy doing 10 to 20 or 20 to 40, or life, who cares what it is. It's some larger, more than a year or two in jail, we'll say. He or she then goes, well, I really don't want to be in jail. What's the only other way I can get out of jail? Well, I can try to come up with a reason why my lawyer was ineffective. So a lot of these are what we would call, Hail Marys, to borrow a football term. But let's assume that you have some colorable argument. What ends up happening, and this is the thing that a lot of the defendants don't realize, once they file the PCRA and they go forward, the privilege is waived, for instance. So now when I'm being asked why I did what I did, I could say, for instance, well, the client told me he did it. Or I could say, well, the client wanted me to call that witness, but he told me that witness wasn't actually there, and I wasn't going to suborn perjury.
Right.
Or more frequently, though, it's just the allegation will be made. But now here's the best part of it all. So remember the prosecutors and how they growl at the defense attorneys, and they want to, they want to punch us. We want to punch them at trial. We're the enemy. They're the enemy. Blah, blah. They suddenly become your lawyer. So the prosecutor, who was your adversary, now sits at the table with you and strategizes with you to defend your work, and argues to the court what a brilliant defense attorney you were. And I always love it, because whenever I'm in a PCRA, I always tell, I'm like, you're the best attorney I've ever had. You've said so many good things about me today. So, yeah, and that's kind of how that goes down. And so yeah, but I have been ineffective before. I've been found ineffective. I remember one time I just completely missed an issue involving a constitutional dimension. And I was so excited about this other issue that I lost on. I never filed on the no-brainer issue. But I also realized it later, and I'm the guy who said to the client, I'm like, looking back over this, I think I should have filed something on. So, write the public defender a letter or file a PCRA and say this is how Rominger goofed up.
Okay. At what point does the client attorney privilege stop? Is it when he hires a second set of attorneys?
No, the privilege is still there, okay? Only when he goes into court and tries to claim that we did something wrong or should have done something differently, we can then defend with what the client told us.
Okay.
So we don't get the right to just divulge everything. And just so you know, the thing is, a lot of defendants who file PCRAs end up withdrawing them, because a lot of them are filed after guilty pleas, which is, I'll tie this back to the Penn State thing. They go, my lawyer didn't advise me adequately, and I'm unhappy with my plea. And here's what happens when you undo the plea. When you undo the plea, you get back to step one. So I'm wondering, let's talk about Corbett's lawsuit for a second. If he wins, right, and he wins and says, you can't do this is too harsh, I'm not sure that's what a court would say. The court might say, well, all right, you were bullied into this position and you took it, so why don't you do a hearing on the merits? And it goes back for a hearing on the merits. Well, what if the NCAA came back after hearing on the merits and said, you're right, we're not giving you the death penalty, but we're giving you an $85 million sanction?
I got you. Okay.
So sometimes what happens when the guys want to withdraw the guilty plea and they're like, well, my lawyer goofed up this and my lawyer goofed up that, the other lawyer goes, yeah, you're right, he should have told you this or he should have told you that, or maybe they did something wrong. But the only remedy is you get a trial. They don't dismiss the charges. So you're still really guilty and you're still going to go to jail longer because it was a decent plea. So then a lot of those get withdrawn. I just find that interesting because maybe that's the remedy. I understand that Corbett's ideal situation would be to tell the NCAA they can't do anything. But think about it from a court standpoint. What are you going to tell the NCAA? You can do some stuff, but not that stuff? Or, in other words, it's asking the court to micromanage it. So a court's more likely to say, no, guys can go back and strike a new agreement. And, of course, I'm in the NCAA. I'd be like, well, why am I going to strike a new agreement? Because every time I strike an agreement with them, they complain about it. So a court's more likely to say, guys, you got to go back and just go through the normal process. Don't strike an agreement, and then you can challenge the result through the process and potentially in court later, and then we'll determine if it was an unfair result in that scenario. But then they could give the death penalty or the $85 million sanction or a $12 million sanction.
Right, yeah. Okay, well, I appreciate your input.
Right. A lot of food for thought, Gary. Thanks.
Okay, have a good day.
All right, 540-0580. Jim, you're on the air.
Hi, Carl. Thanks for taking my call.
No problem.
Hey, I signed a real estate contract to sell a piece of property. The contractual settlement date came and went without the settlement. I'm refusing to sign the release of the buyer's deposit.
Okay.
Now I'm being told by the buyer's realtor that I cannot resell the property until I sign his release. Is that true or false?
So you're technically still under contract?
I'm sorry, Carl. You broke.
Are you technically still under the contract right now?
No, the contract date has gone.
Yeah. And I'd have to read the contract because we have magic words, which is time is of the essence. And we do say that in contracts that time is not specific always. But if you put the magic words in there, the time is of the essence, meaning it's very important in this contract, then we'll hold things to a stricter time. But you're saying the buyer missed their deadline and they want you to sign a release and give them back their $1,000.
Correct.
And you're saying you missed it. I want my $1,000. Right. I think you're okay to enter into new contracts, but it's going to have to do a big question of how much time has expired if the magic words time is not of the essence is not there.
Yeah, well, we're 3 weeks past the settlement date.
Yeah, and I don't. Yeah, and see now you're in the lawyer world. I don't know what 3 weeks means, and so here's the question. I would probably want to do some research on that question, or I would want to talk to somebody to find out what's the standard in the industry. In other words, is 3 weeks past considered a big deal or not? So, if this makes sense, in every contract, there's implicit terms that are created by the standard transactions and the understanding in that particular industry. So, you expect a milk truck to come every day, right? Because it's got to pick the milk up every day. And you probably don't even need that in writing because that's just the way it's done because the milk's got to be fresh. So everybody kind of gets that, right? So if the milk truck doesn't come for 2 days, he's probably in breach of his contract. On the other hand, if they tell you your package is going to arrive in 4 to 6 weeks and it shows up in 8, most courts and people are going to tell you, well, that's just life, right? Because we all expect a couple extra weeks on those, even though they tell you some amount of time. That's not strictly in that time frame. So that would be the question, and I don't know the answer. But you're close, okay?
Mm-hmm.
All right. 540-0580. When we get back from the break, we'll keep talking about all things legal.